How do I challenge a house deed that was signed using a power of attorney when the paperwork and notarization seem wrong? You can challenge that kind of deed by focusing on three main issues: whether the power of attorney was valid and in effect when the deed was signed, whether the agent actually had authority to make that specific transfer, and whether the agent violated fiduciary duties by acting disloyally or for personal benefit. In many cases, the strongest arguments are that the agent exceeded the power of attorney, or that the transfer was self-dealing, an improper gift, or a breach of fiduciary duty, especially if the deed benefited the agent or someone close to the agent. Notarization and acknowledgment problems can matter, but some technical defects may be validated by curative statutes depending on the type of defect and when the deed was acknowledged and recorded. So you usually do not want to rely only on a minor notary mistake. Practically, you start by getting certified copies from the Register of Deeds of the recorded deed, the recorded power of attorney or its recording reference, and the notarial acknowledgment page. Then compare how the agent signed and what the power of attorney actually authorized, including any limits on gifts or transfers to the agent. The usual legal path is a civil court case asking the court to set aside or cancel the deed and, when appropriate, impose a constructive trust, sometimes coordinated with the estate proceeding if one is already pending. If there is a risk the property will be sold or refinanced quickly, you may also ask the court for temporary relief to preserve the status quo while the challenge is decided. And timing matters if a hearing is already scheduled.